submissions of the state as set out in our written submissions in chief. Like the submissions of the state this morning, the National Federation Party's principal submission is that the Constitution, the 2013 Constitution, was imposed on the people of Fiji. The amendment provisions in Section 159 and 2 and 160 were deliberately drafted to shield the Constitution from amendment. They are fundamentally inconsistent with the principle of popular sovereignty, which is enshrined in the Constitution and reflected in both the preamble and Section 3. Like the state, we invite the court to hold that those provisions are unconstitutional, even though they are in the Constitution. We differed in our principal submissions as to what, as a result of that, we submit, like the state, that the supermajority of Parliament and the supermajority of the referendum should be read down and excised from the Constitution. In our submissions in chief, we had differed from the state in submitting that a simple majority would be dangerous, and we had invited the court to read in a 2/3 majority of Parliament for the supermajority, but understanding that the court's jurisdiction to do that, to read in rather than just excise, is a contested matter. We are persuaded by submissions made this morning in chief on behalf of the state, what was implicit in their submission, that if the court were to ignore Section 152 and 160, before the House, or what has just been presented to the House, is a bill referred to in submissions by Counsel for the State that would amend the 2013 Constitution by inserting a 2/3 supermajority in Parliament. That bill was passed by more than a simple majority, more than a 2/3 majority, just short of a 3/4 majority. And should the court accept the submissions of the state that Section 1592 and 160 should be excised as contrary to the spirit and underlying value of the Constitution, we invite the court to advise the Cabinet that the bill that has already received the assent of more than 2/3 of Parliament may be presented to His Excellency for assent, and thereby amend the Constitution so that a 2/3 majority of the House will be sufficient to amend the Constitution without a referendum. So, because we are brief,
Sorry, could I was just thinking that through. Didn't the bill fail to get a majority on the second reading?
It failed to get 3/4, my lord.
Yes.
But it got more than 2/3, and it got more than a simple majority.
So it would have to continue through the parliamentary process.
Yes, my lord. But the bill, if it continued, provides for a 2/3 supermajority.
So that means that there's a select committee hearing.
Yeah, that is.
All of the above, my lord.
Right.
But it is to give credit, it is implicit in the state's submission this morning. I think for want of time it may not have been expressed, but it is a bridge between the position of the state and the concern of the National Federation Party that there must be some form of supermajority to protect the voters of this country.
And you agree with the state submission that it would be wrong for the court to effectively write in the 2/3 majority?
Our submissions in chief suggest that the court may do that, and we invite the court to do that. But if the court accepts the submissions of the state and of other interveners, that the court does not have that power, we respectfully submit that this is a workable solution in the context of the real events that give rise to this reference.
Thank you.
You're saying that the bill may be presented to the President without the referendum.
Yes, my lord.
The referendum is part of the amendment provisions.
Yes, my lord.
So what are you telling us via the referendum? Because constitutionally, referendum has not been used in the 1970 Constitution, 1990 Constitution, and 1997 Constitution. But it first appeared in the 2013 Constitution. What is your view on that?
We support the state's argument, my lord, that the introduction of not just a referendum, but a 3/4 majority of, and we read it like the state, of all of the registered voters in this country is a impossible provision to meet. We agree with the state. It's part of the impossibility of amendment that was deliberately inserted into the Constitution. We invite, like the state, we invite the court to find that it is invalid. Like the state, initially in our submissions in chief, we invited the court to read in a 2/3 majority on two bases, that it was what was provided in the 1997 Constitution, and it was also what was recommended in the Yashkai Commission. But if the court should find that it does not have power to read in the alternative, we default to the position of the state, which we had initially differed from, and accept that for the purposes of amending the Constitution, as Section 1592 and 160 would have been found invalid, they can be replaced by a simple majority. In the circumstances that the court faces today, there is a bill that is already in the House and has passed once by a simple, has received the support of a majority of members of the House, and we would respectfully invite the court to advise Cabinet that that bill, if 1592 and 160 go, that bill can continue in the normal way to introduce the 2/3 supermajority of the House. So that is the device to get there. We would also, in the alternative, although we've not had time to explore it, if the court does not accept that reasoning, we would accept Honorable Justice French's approach of coming from outside the Constitution, looking at whether the Constitution has been validated by efficacy as a whole. And we would respectfully submit that although we do argue that the 2013, given the passage of time, the elections, the absence of the other institutions of state, and the fact that the players, if I may call them that, who were in place under the 1997 Constitution have passed away, we have no government in waiting, we would respectfully submit that as a matter of the efficacy test, the 2013 Constitution is in place, but the court can, we would respectfully submit in the alternative, find that the amendment provisions have never been accepted, they've never been tested, all of the other provisions have, and that the court, on that basis, from an external point of view, may say the Constitution, the 2013 Constitution as a whole, save for the amendment provisions, meets the test of efficacy. So by either route, or by either of the three routes, any of the three routes, we would respectfully submit that the amendment provisions, as they stand, should be found unenforceable. So if I could go to the questions, we would answer the question 1 and agree with the state that the answer to question 1 is no, that the provisions of Chapter 11 and Part D of Chapter 12 are not binding on the people of Fiji. Question 2, may the provisions referred to in question 1 be amended following enactment of a bill in Parliament to do so in terms thought fit by Parliament? We would say yes. In terms of the bill that is now before that was introduced into the House recently. Question 3, is approval of any amendment proposed in accordance with question 2 effective only if approved by the people of Fiji at a referendum? We agree with the state that the answer must be no.
Why?
Because we would respectfully submit that there is no history of referenda.
But there's no history of a single House of Parliament in Fiji being able to change the Constitution with a 66% majority.
That is true, my lord. But we would respectfully submit that a referenda would, in the circumstances of this country, be an expensive, divisive.
It could be conducted at the same time as a general election.
It could, my lord, but usually constitutional amendments don't wait for a general election. A constitutional amendment, the need for a constitutional amendment may arise from a situation that arises midterm. It could come, from a realization that there needs to be modernity. I think also a point that has not been made in the chronology of facts is that Fiji is a country in transition. I have lived long enough to have been at Albert Park when independence was granted to us and the 1970 Constitution was given to us. I've lived through the coups, and I've been involved in constitutional formulation over the years. And the one thing that strikes me that has not come through in the submissions is this society has changed dramatically and is continuously changing. The concerns that guided the compromise in the 1970 Constitution, the issues that LegCo members battled over in London no longer exist. The numbers have changed. The same issues as in 1987 don't exist to the same extent. The numbers or the arrangements that were made, the compromises that were made in the 1997 Constitution, and for the information of your lordships and your ladyship, I was one of the legal counsel to the Constitution Review Commission. The issues that the commission had to deal with no longer exist in the same way. The most important issues, the demographics of this country have completely changed. The inter-ethnic relations, the relations between the communities have changed. There is no longer such a huge division. There is no longer such a communal division in the organization of political parties. We've moved on. So we need to bear in mind that constitutions need to be flexible enough to meet ever-changing circumstances. as a small island state, relatively poor, always going to face immigration as our citizens seek better opportunities elsewhere. Everything will always be in a state of flux. We will face challenges that we cannot think of today. I mean, who would have thought that climate change would be such an issue? That was not an issue in 1990. It was not an issue in 1997. COVID, all of these challenges happen all the time.
These various factors that you mentioned seem to have persuaded Eshkai that there needed to be a public process when you were thinking about constitutional amendments. And from memory, what that group advised was that there would be a sort of people's assembly, and he did not favour a referendum because of the cost and the possibility that it could be manipulated. But he certainly favoured public participation, specifically around what the suggested amendments were. Now, one of the, if you look at it in the design terms, and it may be that this is not an issue for us at all, but a justification for the double requirement, Parliament and a referendum, is that a referendum does involve the people. And if you get the proportion right, you may well have a meaningful referendum rather than one that is unlikely ever to be met. So how do you see public participation directed to particular amendments occurring?
My Lord, in the ideal world, if this court were Parliament, I would invite the court to read in and design some mechanism for public participation other than a referendum. Because like, with all due respect, like Professor Guy, I have personally, and my client's position is that a referendum is not desirable, both for financial, but also for manipulation reasons. We would, in principle, if this were Parliament, I would say, fine, go with the National Assembly. But this is not Parliament, and the ability of the court to advise Cabinet that this is read in, I'm not sure, I have hesitation whether you have that power, my Lord.
The other day, I was thinking of a standing Constitutional Review Commission. Why? One of the problems in this country, I also noted, like you, I've lived long enough to come through all these interesting
You maybe have lived a little bit longer than me,
Oh,
my
am
Lord.
I? Okay. But my point is that I had suggested to my brother judges and the lady judges that we should have a standing Constitutional Review Commission that is constantly looking at this issue and not wait until something happens and everybody gets jumped up with their emotion and come and make a very nothing useful to say most of the time. Because, I mean, those are the, otherwise it's going to be like, I agree with what you're saying this morning. It's hard to try and suggest this thing with that. Because it is very costly. And then we have to go and ask Australia again for some money.
And with all due respect, my Lord, although I have waxed lyrical about how there's been change, issues like that are divisive by nature. And now accommodations, as much as they have now come into being, are still fragile. And so things like a referendum that goes out to the public runs the risk of inviting those who wish to cause division to do so. So that's my personal hesitation. The alternatives, my lord, is if you read down the provision so that the 3/4 majority of the referendum were gone, but the referendum was still there.
I suppose
So it'll be a
Mr.
simple
Apted,
majority.
if we were to go down the path of recognition of the Constitution as a whole subject to a qualified recognition of the amendment provisions, leaving in place a mechanism for what I might call the democratic repair of the Constitution by amendment. What are the, you've probably answered this already in part, at least by what you've said, but can you just encapsulate what are the factual, practical barriers to the utility of a referendum, putting aside 3/4 majority to that, in that process?
To be honest, my lord, I have no experience for referendum in this country, so this is all conjecture.
Yeah.
I have, again, the learned Chief Justice and Mr. Justice Taitonga are familiar. I was the supervisor of elections for 2 elections, so I speak from experience of running elections or running polls. It's a mammoth exercise. It's very divisive. In a small country like this, it focuses a lot of energy. It's distracting. A lot of energy, both in the administration of the state and in society, goes into that exercise. It's all-consuming. So
I suppose we can draw some inferences about that from the reports of the Electoral Commission about the processes undertaken in relation to the conduct of, for example, the 2022 election.
yes, my lord. It's very, very contentious. There's always challenges. There's always issues about qualification, about opening times of the polls, and it's hugely troublesome. And this is a litigious society. That's part of the reason that I hesitate. And thank God that it's litigious, but never mind.
Keep some people in work.
Given your experience, maybe you could answer a question for me. I was very puzzled when I read section 160, subsection 4, which says the referendum for the purpose of subsection 3 shall be conducted by the Electoral Commission in such manner as prescribed by written law. So I searched everywhere. I couldn't find a written law about referendums.
There isn't one, my lord.
Right.
They never got around to prescribing one because it's never supposed to happen. I mean, that's the gist of the state's case, that all of these amendment provisions are illusory because they were designed to make amendment impossible, at least.
Fiji, since 1970, and the election that has been done since then, has always proceeded on the basis that the representative of the people are the members of parliament. There was no need since then for a referendum. And then I've heard submission that the referendum amendment provision in the 2013 Constitution is designed by the people who constructed the 2013 Constitution to suppress people's sovereignty as mandated by Section 3. When there are inconsistent provisions within the Constitution, we have to be guided by what is meant by freedom, human dignity. What's your view?
I agree with the arguments of the state that the referendum had no precedent. As part of this constitutional framing exercise, the very person who was charged under the decrees for making recommendations recommended against it. So against that context, you see a referendum coming in all of a sudden, and forgive me correct me if this is in error, but I understand that the explanatory notes that were recently shared show that the original supermajority was 2/3,
Yes.
and suddenly and immediately
Yeah, out of the blue,
it became
overnight, yeah.
3/4. And the question is, why? And it can only be, with due respect, to ensure that the Constitution that the framers were bequeathing to the plebeians was permanent, and that the people were effectively deprived of their own sovereignty to determine their constitutional future.
So from your viewpoint, what should the court do in terms of the referendum provision? Withhold recognition? Or what?
Thank you for the question. Our submission, like the state's, is that the court should find that 1592 and 160 are invalid as contrary to popular sovereignty. But if the court does not wish to do that and comes at it from a different point of view, we would invite you to ignore it or read out the 3/4. Those are the three alternatives, depending on which way the court wants to go. I mean, there's no right answer to this, my lord. We're in a very difficult situation. The National Federation Party wishes to be helpful. We don't believe we're right. We are hoping that with the benefit of the state submissions and the interveners, the court can assist the people of this country with an opinion that helps us to move forward with a constitution that we control.
Naka.